Hello, this is Matt on the Moon Lambeau channel, and Ripple CEO Brad Garlinghouse has hit back against claims placed by the SEC in a new document that was filed to Judge Annalisa Torres, who is overseeing the SEC versus Ripple case. And it was interesting for a number of reasons. Starting with the fact that there are a number of new legal defense claims within this document that haven't been articulated to this point publicly, anyway. And I'll tell you what, this was worded in such a way, this document, it was worded in such a way that it is super easy to understand. Like, that you do not need to have a legal background to get the gist of what was discussed within this thing. So I want to run through this thing and share with you some thoughts along the way. But I'll tell you, my initial impression, and fine, you can call me biased, but in going through this, I just thought, holy hell, good luck SEC. So specifically what this document is, it's a document that is required to be filed by this particular judge anyway, before a motion is placed. So it's a summary of a motion that is yet to be filed. In this case, the motion in question would be a motion to dismiss the SEC charges against Ripple CEO Brad Garlinghouse. Now, I do want to be clear that I don't have a legal background of any kind, so I'm not offering legal advice. I also don't have a financial background of any kind, and so I'm not offering financial advice. You should not buy or sell anything because of anything that I say or write. I'm nothing more than an enthusiast that likes to talk about crypto and XRP and Ripple related things and make YouTube videos as a very fun hobby, but that is indeed all that it is. And so here's a tweet from Ripple CEO put out just this afternoon, which reads as follows. Today, a letter was filed on my behalf indicating my intent to file a motion to dismiss in response to the SEC's amended complaint against me. Simply put, the SEC's allegations are regulatory overreach. The letter speaks for itself. And I noticed here, there's a tweet from attorney Jeremy Hogan. I'm sure many of you are familiar with him. I've highlighted him on my channel a number of times. He's been sharing some very valuable insight, given that he is an attorney here. And so he wrote the following in response to a tweet that has since been deleted. So I don't know what that one was, but I wanted to highlight this because it is interesting. He wrote, Judge Torres requires pre-motion letters and limits them to 4 pages. Notice how they squeezed every single sentence in that they could. Twitter is good practice for that, he writes in parentheses. Once she receives the letter, she will tell them when and how to submit the legal motions. And I will tell you, so now I'm just scrolling through, this is the actual document that was filed. It did strike me how scrunched everything was even before I read that tweet from Hogan. I didn't know that there was a 4-page limit. And then I got down to the bottom here, and technically there's a 5th page, but it's just a signature. There's no actual content. And I thought, well, that's a strange formatting choice. I was thinking that to myself, I was like, why would they do this? Is this common practice? And indeed, it's just the case that they're trying to cram as much information as they can inside of those 4 pages. I wonder if they could have made the margins a little bit wider. You know, that would have been nice. All right, so in we go, though. Dear Judge Torres, on behalf of defendant Brad Garlinghouse, we write pursuant to Section 3 of Your Honor's individual practices, setting forth the arguments that Mr. Garlinghouse anticipates raising on a motion to dismiss the SEC's first amended complaint pursuant to, and then they cite what it's pursuant to. I'm going to try and skip over as much of that as possible. But in terms of the actual content and being able to, just being a lay person, understand it, not going to be an issue here, but I'm going to skip over as much of that type of stuff as I can. Anyway, this case represents regulatory overreach, plain and simple. On December 22nd, 2020, the SEC brought this suit, alleging that Mr. Garlinghouse engaged in a scheme with Ripple Labs that allegedly had been taking place right under the SEC's nose since at least 2013 to continuously and unlawfully sell XRP, which transactions the SEC alleges should have been registered as securities all along under Sections 5A and C of the Securities Act. Do you ever sit there and think, like, given that this went on for 8 years, that the SEC, by choosing to not take action, if what was happening was illegal and wrong, they allowed, by their inaction, investors over an 8-year period to get harmed. Anybody ever think about it like that? In what world does that make logical sense? But hey, SEC, everybody, round of applause. The linchpin of the SEC's case is its recent revelation that defendants' transactions in XRP, a digital asset used to make faster, cheaper, and more efficient payments and money transfers, are and always have been a type of security called an investment contract, despite the contrary understanding of the XRP market for more than 8 years. The SEC's allegations fail for a number of reasons. Now, some of these you'll have heard before I go, I'll just cite that. Some of these arguments you'll have heard before, but some of them are unique to this particular aspect of the case, and they are interesting. Now, first, the SEC fails to recognize the economic realities of defendants' transactions in XRP, the XRP market, and Ripple's business, each of which exhibit none of the traditional characteristics of an investment contract under SEC versus W.J. Howey, which was from 1946. You guys are familiar with that case at this point, right? Anyway, Howey requires the SEC to show, among other things, that defendants agreed with XRP purchasers to form a, quote, common enterprise that was dependent upon Ripple's managerial efforts for profit. But Mr. Garlinghouse's XRP sales involved no contract of any kind with the buyers, as his sales were done anonymously over an exchange. Nor were the proceeds of Mr. Garlinghouse's sales pooled with other buyers in a common enterprise. So pause and think about that. If somebody is purchasing XRP and they don't even know that it came from Brad Garlinghouse, how the hell does that constitute an investment contract? Well, yeah, if anything, if you know it's come from Garlinghouse, oh my gosh, let's pay a premium just so you can say you've got Garlinghouse's XRP. But no, nobody even knew that. Nobody knew that. It's completely absurd. And XRP's value historically has not been correlated with Ripple's actions, results, or public announcements, but instead with changes in the value of other digital assets, such as Bitcoin and Ether, that the SEC has publicly declared are not securities. Moreover, in 2015 and again in 2020, the Department of Justice and the Department of Treasury's Financial Crimes Enforcement Network, or FinCEN for short, found XRP to be a virtual currency. That's a legal definition, by the way, virtual currency, requiring Ripple to implement anti-money laundering controls generally not applicable to securities transactions, which it did and continues to do. Second, not satisfied simply to try to fit the square peg of XRP into the round hole of the securities laws, the SEC has also chosen to target Mr. Garlinghouse with personally violating the securities laws, both by selling his own XRP and by allegedly aiding and abetting Ripple's sales. And guys, before we go further, these are legal terms that have consequences. You know, if you're making these claims, you better have some sort of strong legal argument to really tie it all together in the courtroom. Are you gonna have a bad time? And I think the SEC at this point is probably gonna have a bad time, as will be evidence as we keep going through. You will see why. Check this out. Now, straining to impose personal liability on an executive like Mr. Garlinghouse for simply doing his job where he reasonably understood that his actions complied with the law represents an abuse of prosecutorial discretion that has sent a dangerous signal to entrepreneurs and will chill innovation. Effectively conceding the deficiencies in its original complaint, the SEC elected to amend on February 18th, 2021, after Mr. Garlinghouse pointed out various defects in the pleadings. So for those of you that missed what they're talking about there was an original complaint of the SEC versus Ripple, and then there was a complaint against Brad Garlinghouse and Chris Larson, co-founder of Ripple. And those complaints were filed on December 22nd of 2020. Now, ultimately, the SEC came back and amended their complaint. because I think that they knew that their case against Mr. Garlinghouse, the way that they had typed it up in their original, I think 79-page complaint, wasn't really going to stick, you know. And so part of the reason is, and then this is what they went back for. You could tell that this is what they were going. And we talked about on the channel too, but this is what they were trying to change. Effectively, the language in the amended complaint, it really had almost exclusively everything to do with Brad Garlinghouse and Chris Larson too, really. Having understood, not like literally having understood that what they were doing was illegal in the moment. And so I think that's where this language, like aiding and abetting is coming in here effectively. It's just this idea that they knew it was wrong and then proceeded without knowing it. So there's one thing to like do something and then it's illegal and then you find out about it, but there are legal implications. It's worse if you knew it first and then engaged in the activity, or if you were like, quote unquote reckless, which is another legal distinction behind it here. And so that's why that's all important. But anyway, these were the exact same defects, among others, Mr. Garlinghouse had already pointed out during the investigative process. The SEC's amended complaint fares no better. The SEC has not adequately alleged that Mr. Garlinghouse knew or recklessly disregarded that defendants' transactions in XRP were investment contracts, or that Ripple was somehow acting improperly in selling XRP such that he can be liable for aiding and abetting Ripple sales. Nor, under Supreme Court and Second Circuit precedent, can the SEC establish that Mr. Garlinghouse's sales and offers of XRP fall within the territorial scope of the Securities Act. And this gets interesting too, so check out this point that they wrote here. The amended complaint fails to adequately allege Scienter, a necessary element of the aiding and abetting claim. And so Scienter, it's a legal term that just means that you effectively knew beforehand that what you were doing was wrong, which is why I was stating just a moment ago, if you don't know it's wrong, from a legal perspective, it's bad, not as bad. And so that's what they're talking about with Scienter, and that term is going to keep coming up, which is why I wanted to make sure that you guys are aware of what that means. Anyway, the amended complaint purports to allege that Mr. Garlinghouse aided and abetted Ripple's unregistered sales of XRP. While violations of Section 5 do not require a showing of Scienter, aiding and abetting does. And so there you go. That's the key part. So if he was aiding and abetting, he must have actively known that he was doing so. And that's what they're stating so right there. Now, the SEC has the burden to demonstrate that Mr. Garlinghouse either knew or recklessly disregarded that he was associating himself with something improper and nonetheless substantially assisted, and that's in quotes, substantially assisted, which means it's key, Ripple in committing that violation. All right, move a little bit lower here. Here we go. They cite this too, requiring the SEC to show that defendant knew or recklessly disregarded that the underlying activity was improper to prove aiding and abetting a non-Scienter violation. Now, after a 30-month investigation, and after the production of more than 200,000 pages from defendants and third parties, the best that the SEC can do is allege that Mr. Garlinghouse was generally aware of the risk that some digital assets could possibly be deemed to be securities, but that he worked hard to ensure that XRP did not even appear to have those features. For example, the SEC alleges that Mr. Garlinghouse participated in discussions about messaging around XRP to make sure the verbiage doesn't put us at risk of XRP sounding like a security, and that's a quote. That Mr. Garlinghouse demonstrated a keen interest in the regulatory status of digital assets, and that Mr. Garlinghouse liaised with various exchanges who sought comfort that XRP was not a security as a condition of listing. And so, that's why I want to pause here for just a moment. Just understanding that there is a possibility that, a part of the federal government could charge you with something, that doesn't mean that that charge is valid or that it's reasonable to assume that should such a charge come through, it would in fact be the case, that it would be legally evident, like legally true. like, think about it, and this is stupid. Like, this is not a real world example. Just imagine if the SEC, like, you caught wind that the SEC was going to insist that the sky is purple every single day. Even if you knew that they were about to claim that the sky were purple, it doesn't mean that you believe that the sky is purple. It just means that you know that they might make a stupid claim. It's dumb, you know? And that's exactly how the way that they were looking at it. It makes me think back to a comment that Greg Kidd made. He was Ripple's chief risk officer from 2013 to 2015. And he was making that exact point. You know, just because you know that there could be a claim brought, it doesn't mean that it's a valid claim. You know, just like in my stupid example of if the SEC were to insist that the sky were always purple, and that if there was some sort of, you know, legal fallout as a result of that, well, still it doesn't mean it's true. So it's completely ridiculous here. But anyway, these allegations, which only show the efforts of a prudent executive trying to get it right, do not cut it. The SEC fails even to adequately allege negligence. And check this out, guys. I love this part. Let alone the far more onerous knowledge of recklessness standard. Alleging that Mr. Garlinghouse was aware of the mere risk that a transaction in XRP might be classified as a security is a far cry from plausibly alleging that Mr. Garlinghouse knew or recklessly disregarded that defendants' transactions in XRP were securities. Then they go on to cite some cases. So we go a little bit lower. Defendants' recognition of generalized risks does not constitute recklessness. Exactly, which goes back to the stupid example I made about the purple sky. Just because you know there might be a bogus claim brought doesn't mean you're being reckless because you're aware that there might be a stupid claim brought. Anyway, the SEC has suggested that it would be sufficient to show merely that Mr. Garlinghouse knew that Ripple's offers and sales of XRP were not registered with the security. So there you go. That's nailing it. The SEC thinks it's a sufficient legal claim that Garlinghouse, he's made a boo-boo purely because he knew that a bogus claim might have been brought against him. It's completely bonkers, but that's what the SEC is doing. This is so well articulated by Mr. Garlinghouse's attorneys here. And it continues. But this theory fails to distinguish between substantially assisting legal conduct as opposed to improper conduct, and would essentially transform aiding and abetting into a strict liability offense. Even where the underlying violation does not require Scienter, in order to establish aiding and abetting, the SEC must show that defendant knew or recklessly disregarded that the underlying activity was improper. But it is worse than simply a pleading failure. I gotta tell you, as I was reading through this the first time, I was just like, wow, this just keeps getting worse and worse for the SEC in terms of how it's looking here. Oh my God, they did. I don't know, like, do you even lawyer, SEC? Like, do you even lawyer, bro? Come on. The SEC's own allegations demonstrate that, like the market more broadly, Mr. Garlinghouse was inundated with evidence that defendants' transactions in XRP were not investment contracts, undermining any suggestion that he understood that he was associating himself with something improper. Right when Mr. Garlinghouse joined Ripple as chief operating officer in 2015, the company finalized in a public enforcement settlement with the Department of Justice and FinCEN on the basis that XRP was a virtual currency, in which the company agreed to undertake remedial steps applicable to currency transactions and inapplicable to securities transactions. Likewise, the SEC alleges that XRP was listed on digital asset trading platforms, some of which have their principal place of business in the United States, and none of which are registered with the SEC. So think about that. If the SEC is clear, it's like a tacit implication of acceptance by the SEC, because XRP had been traded on American exchanges for years. Why would Brad Garlinghouse come in 2015 and think that there's some sort of problem with the legal designation of XRP as a virtual currency and not a security? That wouldn't make any damn sense, and that's the point that they're making here in this piece right here. And so they don't allege that these third parties believe that defendants' transactions in XRP were securities, and consequently that they were violating the law. And there's no reason to believe that they did or they were. Now, however, the SEC has determined that in the face of government action and market consensus, Mr. Garlinghouse should have unilaterally reached a different conclusion. That defendants' transactions in XRP always were investment contracts, and that it was at least reckless for him not to do so. Think about that. So he'd have to, he's saying that on his own, Brad Garlinghouse unilaterally would have to disagree with all of the other actors in the market, including cryptocurrency exchanges, that some of which ultimately ended up contacting the SEC to try and get clarity around this, all of which determined XRP could not possibly be a security. But Brad Garlinghouse here, he was supposed to know better, right? because there's such clear guidelines, right? Oh my gosh. It's just so disingenuous, these charges. I really grinds my gears. Anyway, so moving on, but under these circumstances where Mr. Garlinghouse is understanding that defendants' transactions in XRP were not investment contracts was reasonable based on all available facts, and where the applicability of the securities laws to XRP clearly allows for more than one reasonable interpretation. It would defy history and current thinking to treat a defendant who merely adopts one such interpretation as a knowing or reckless violator. Exactly. I don't know how you defeat that logic. Now, sum up, what is fatal? And this is like the nail in the coffin coming up here. What is fatal to the SEC's aiding and abetting claims is the lack of any plausible allegations that Mr. Garlinghouse's state of mind ever crossed over from general awareness of the risk inherent in the digital currency space that a digital asset could be classified as a security if certain criteria were met, to knowledge or recklessness that defendants' transactions in XRP specifically were or are investment contracts, or that Ripple was somehow doing something wrong. Without this, the SEC's aiding and abetting claim must be dismissed. And we're really getting to it here. The amended complaint fails. Check this out. This is like laughable, but it's true. Check this out. The amended complaint fails to allege that Mr. Garlinghouse's sales and offers of XRP fall within the territorial scope of the Securities Act. Oops, a little bit of an oversight there. Even if defendants' transactions in XRP were investment contracts, which they are not, the SEC's allegations regarding Mr. Garlinghouse's personal offers and sales of XRP likewise still fail to plead relevant transactions by Mr. Garlinghouse in the United States. Well, why would that be? Well, check it out. This is a critical failure. The registration requirements of Section 5 of the Securities Act apply only to offers and sales of securities in the United States, and do not reach offers and sales made on foreign exchanges. And so they cite here too, Congress lacks the power to regulate foreign securities exchanges. Tellingly, the SEC knows the details of Mr. Garlinghouse's XRP transactions perfectly well, and yet nowhere in its 79-page amended complaint did it allege the particulars of even a single offer or sale of XRP by Mr. Garlinghouse in the United States. Instead, the SEC alleges merely that Mr. Garlinghouse has sold over $357 million of his XRP for approximately $159 million, and that these transactions occurred on various digital asset trading platforms, including 2 platforms that were incorporated in the United States and one with its principal place of business in New York. These vague allegations seek to obscure what the SEC knows but merely hints at with a passing reference to Mr. Garlinghouse's, quote, worldwide sales. The truth is that the vast majority of Mr. Garlinghouse's XRP sales were made on foreign exchanges, and those transactions do not and cannot violate the federal securities laws. Well, how about that? A little bit of a jurisdictional issue, which is something that I've discussed on this channel, something that was first brought up by attorney Jeremy Hogan. How about that? Or at least that I first noticed anyway. That's where I first saw that. And by the way, as far as the sales of this, some people still out there in the XRP community, they're like they feel like double crossed or some such nonsense because Brad Garlinghouse was selling XRP while the price action was doing what it was doing. Mind you, like he sold like a ton of what he sold was before the parabolic rally last market cycle. So, but that really should that doesn't even matter. The fact that he missed out on the top of the market, set that aside. Look, when he was hired in 2015, he got XRP as part of his compensation package. And if he's getting that, that means that whatever he would have earned in terms of USD, it would have been affected. Like, it's all taken into consideration there. And what he does with what he has earned as a result of his compensation package for the work that he's done, whatever he wants to do with it is none of our damn business. It is absolutely none of our damn business. If he wants to sell some of his XRP, look, as long as he is still acting in good faith, excuse me, sorry guys, as long as he's still acting in good faith and he's working, to foster a healthy XRP ecosystem, which is part of what, Ripple is clearly doing, I sure as hell don't give a damn. I don't care how much money he makes. Him making that much money doesn't hurt me, and him selling that much XRP is such a small amount in terms of the overall market that it's not measurable in terms of what it would do in affecting price. It is not enough. It's a minuscule amount. You're talking about billions and billions and billions and billions of dollars per day in terms of XRP sale. I mean, it can vary, obviously, depending. I mean, it's volatile, sure. But you're talking about billions of dollars a day in XRP actions, and you're talking about over a span of who knows how long, $159 million with an M and not a B. Like that's no, it's not. It didn't hurt us whatsoever. If you have a problem with that, then do you have an issue? Like, are you just jealous of people that have money? Because that's not a way to live. He doesn't have any special power over you or anybody else. He got a good job. He's a COO initially, and he got a digital asset that wasn't worth that much as part of the comment. Mind you, at the time, it was worth like what, half a penny? It wasn't worth that much money. And then the fact that it went up, I mean, that would have constituted a very large percentage of his overall net worth. And it just makes sense to reduce your risk exposure when something like that happens. It's just balancing of your overall portfolio. But he shouldn't have done that because of reasons? Because you're jealous of him? Like, no, I don't like these arguments. It's just a bunch of like class warfare type of nonsense. I don't dig it. I do not dig it. But anyway, sorry, where did I move on? I think I left off right here. Yeah, here we go. So here we go. I think this is the last sentence I read. The truth is that the vast majority of Mr. Garlinghouse's XRP sales were made on foreign exchanges, and those transactions do not and cannot violate the federal securities laws. Because the SEC has not identified the officer sales, if any, that it contends were conducted in the United States, and that therefore violated Section 5A or C, it fails to state a claim. Guys, think about that. They didn't even make an actual claim, not just in the original complaint, but in their amended complaint, they still didn't make a claim. That kind of matters. Dismissing, they cite another case here, CEA claim under Morrison, so another case, where complaint made no allegations concerning the location of the transactions themselves or the structure of Lyft transactions. I'm not familiar with what Lyft transactions are. It doesn't matter. The point is, there's case precedent here, and they made a boo-boo. They didn't even make a claim. So anyway, the SEC cannot save its pleadings by arguing that Mr. Garlinghouse's offers or sales are domestic simply because either he or XRP purchasers, the location and identity of which Mr. Garlinghouse was unaware, may have been physically present in the United States at the time of the transactions. A Second Circuit precedent is clear that a person does not violate the securities laws by engaging in a transaction on a foreign securities exchange merely by being present in the United States at the time. And so, finding it, they said a case there, finding it insufficient to allege that a U.S. entity, quote, placed a buy order of a foreign security in the United States that was then executed on a foreign exchange. And so, for the foregoing reasons, the SEC has failed to allege that Mr. Garlinghouse's sales and offers of XRP fall within the territorial scope of the federal securities laws. So it's like they hinted that it did, but they never made the claim that it did. So how do you move forward with such ridiculous charges if you, the SEC, didn't even make the case in the first place. It's fascinating. This is a fun topic of conversation here, so it'll be interesting to see quite certainly how all of this shakes out. And you can see then they just kind of wrap it up here. So there will be more to talk about on this. I'm sure all sorts of other people are going to chime in, and I'll be happy to talk about it further. But I wanted to run through this thing and share with you my initial reactions because, like I said, and I'm sure you can see now, there were a number of defenses made here that I just hadn't seen before. It's just obviously they've been talking about this for months behind the scenes here, but now some of it's reaching the surface. And so I think if this makes it to court, we just I got a few more tastes of what might be delivered, in court. So I'm still hoping there's ultimately a settlement, but if not, it's gonna be a sight to behold. Seriously. Tell me what you think in the comments below, but that is it for this latest Moon Lambo hot jam. I am not a financial advisor. Do not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.